morning. This is Birthday News. I'm Amy Ng, bringing you the latest live updates. On the morning of 7 December 2015, a shocking and tragic incident unfolded in Kampong Labuhan Birthday, leaving one dead and another injured in a violent attack.
Two men named Faisal bin Awang and his friend Zulkifli bin Abdullah were riding their motorcycle through the village looking for scrap metals. They stopped near a house where some scrap metals were scattered on the ground. When Zulkifli got off the motorcycle to take a closer look, the man living in the house, now identified as the suspect, suddenly inflicted an attack, riding a motorcycle and holding a machete. He stabbed Faisal in the right chest. Zulkifli tried to help, but the attacker turned on him, stabbing him in the chest as well. Zulkifli ran toward the main road, but the attacker chased him. Even after Zulkifli collapsed on the road divider, the suspect continued to kick him despite his pleas of mercy. The attack only stopped after Zulkifli could no longer move.
In today's sentencing, the High Court imposed the death penalty on the accused for the murder charge and an additional 14 years of imprisonment for causing grievous hurt. The accused was called to enter his defense. He raised claims of private defense for both charges, as well as an accidental defense for the killing of the deceased. The court rejected these defenses due to a lack of supporting evidence and the absence of any grave and sudden provocation from the victims. The convict's legal team is set to file an appeal against both charges, bringing the matter to the Court of Appeal.
This court is now in session to address the appeal by Mohamad Zulkifli Bin Ismail, challenging his conviction and sentences imposed by the High Court. Appellant's counsel, you may now proceed with your submissions.
Your Honor, I represent the appellant Mohamad Zulkifli Bin Ismail in this appeal. The issue before the Honorable Court are, first, whether the High Court judge erred in fact and law in imposing a death sentence and 14 years of imprisonment on the appellant. Second, whether the appellant had an intention or meant to kill the deceased. Third, whether the lower court erred in rejecting the appellant's defense of private defense and accidental defense. May it please the court, we submit that the appellant had no intentions to kill the deceased based on two grounds. First, the stab wound was shallow. If the appellant had intent to kill, he would have used greater force to inflict a deeper wound to the chest. Second, there is no evidence suggesting that the appellant had made preparations to kill the deceased. The machete was merely a tool used by the appellant for cutting meat. We humbly urge this Honorable Court to reconsider the evidence and reduce the charges and sentence accordingly.
Your Honor, the appellant's arguments lack validity as the appellant had intention to kill the deceased based on four grounds. First, the appellant's action is under paragraph C of section 300 of Penal Code, which has intention to inflict bodily injury that is likely to cause death. Second, the appellant's action of stabbing the vital part of the body of the deceased showed intention to kill. And third, the appellant's continuous attack also showed intention to kill. Fourth, the appellant's police report contradicting his oral testimony made his defense unconvincing.
After reviewing the submissions and evidence, we find that the High Court's findings are thorough and comprehensive, while the appellant's findings are meritless. The appellant's actions demonstrated clear intention to cause death. Thereby, we dismiss the appeal and uphold the convictions and sentences by the High Court.
Hey guys, now I would like to present the basic info of our case.
Moving on to legal reasoning. Firstly, the Court of Appeal rejected the appellant's defense. The court found that the defenses of private and accidental defense lack any basis, making them hypothetical and failing to convince the court. For private defense, the court referred to Chun Tai Kong's case, emphasizing that such defense is valid only when the perceived danger is imminent and the response is proportional to the threat. Similarly, for accidental defense, Cases like Abdul Aziz Myeong against public prosecutor and Tok Kian Peng's case highlight the need for strong evidence like eyewitness testimony and proof that the act wasn't intentional or reckless, both of which are missing here. Additionally, there was no evidence of grave and sudden provocation by SP-17 or the deceased prior of stabbing. With reference to the case of Chair Omar Mohamad Akher against public prosecutor, the absence of such provocation cannot establish a defense under Exception 1 of Section 300 of the Penal Code for culpable homicide.
Moving on to the second legal reasoning, the Court of Appeal concluded that the appellant had a clear intention to cause the death of the deceased. The stabbing targeted at the right chest and the relentless attack reinforced this intent. The appellant ignored repeated pleas for mercy, threatened SP-17 to prevent any assistance, and failed to call for medical help despite having the means to do so.
Turning to the third key point, the appellant's defense was unconvincing due to contradiction between his police report and the testimony. First, there were inconsistencies regarding the machete location. In the report, the appellant claimed it was under an outdoor cupboard, leaving no time to retrieve it if it's attacked. However, in his testimony, he mentioned that it was in his motorcycle basket, which also left no time to achieve it while managing the motorcycle. The account of the attack also conflicted. The report claimed SP-17 and the deceased attacked him together, but in testimony, he said he stabbed SP-17 first, and only then did the deceased attempt to strike him with a steel ball. Finally, his claim of not assaulting the deceased further was disproven. SP-17 testified the appellants continued to keep the deceased knocking off his helmet. This was supported by SP's false report of injuries to the deceased arms and legs, and by SP 8, 9, and 10, who found a helmet near the body.
Weakness of judgments. With due respect of the Court of Appeal decisions, we believe that certain aspects in the appellant's conduct may warrant deeper considerations regarding the intent to murder. First, nature of attack. The initial fatal stab was not followed by the further use of machete. Instead, the appellant chased the deceased, resorting to physical assault with kicks and punches while still holding the machete. If the intent was to kill, continued use of the machete would be expected, raising questions about the immediate intent to cause death. Second, subsequent actions. The appellant's physical assault, even though aggressive, does not suggest a sustained intent to kill. The lack of repeated machetes may indicate a lack of premeditations. The deceased died from the initial stab wound, not subsequent injuries, supporting the view that the fatal act was not followed by a deliberate continuation of deadly intent. In our minds, there could be an alternate interpretations. The appellant's switch to physical assault could reflect a loss of control or anger rather than a calculated intent to kill, suggesting grievous hurt. To conclude, the argument does not seek to absolve the appellant, but points to a potential gap of the assessments of intent, suggesting culpable homicide under Section 304 of the Penal Code rather than murder.
We will discuss the case development beyond the Court of Appeal. After the Court of Appeal decisions, Zulkifli Ismail brought his case before the Federal Court, where he withdrew his appeal concerning the charge of causing grievous hurt, focusing solely on the murder charge. Despite this, the Federal Court dismissed his appeal. A key turning point came on 27 March 2023 when the Abolition of Mandatory Death Penalty Bill 2023 was tabled and unanimously passed in Parliament. The new law abolished the mandatory death penalty, making it discretionary. As an alternative, offenders may now face imprisonment for 30 to 40 years with mandatory whipping of no less than 12 strokes. In light of these reforms, Zulkifli Ismail applied for resentencing under this bill. As reported by Malay Mail, the Federal Court resentenced him, reducing his death sentence to 35 years of imprisonment.
We fully support the Federal Court decision that Sir Angeline on my side stated in the Parliament that as of May 31st, 2024, the Federal Court has upheld the death penalty in only 19 out of 474 review applications. These 19 cases involve murders that include multiple victims or child victims. We conclude that the Zulkifli Ismail crime, which is the killing of an alleged robber, would not be deemed to warrant the same level of severity as these more egregious cases by a reasonable person.